If it pleases your Lord, I'm Tzu Wei Junior Counsel for the appellant, and I'll be touching on the second ground of appeal, and that is whether the defense of necessity is available to a defendant charged with murder outside the particular circumstances that arose in VA Children, number 254, case reported in year 2000 in the England and Wales Court of Appeal Civil Division. My Lord, the appellant would like to mention a few cases whereby the courts have based their decision largely on policy considerations. To bring across the point that the same should be done in the appellant's case. My Lords, in the cases of the Crown on behalf of Nicholson against Ministry of Justice, 2381 case reported in the year 2012 in England and Wales High Court, and Adele, the Crown against Dooley and Stephens, volume 14 of Queen's Bench Division, reported in the year of 1884, page 273, and Purdy against Deputy Public Prosecutors, number 92, case reported in the year of 2009, England and Wales Court of Appeal Civil Division. The courts have found policy reasons underlying their decisions. If the appellant may, my lords, direct your lordship's attention specifically to the policy considerations lying behind the decision in Dooley and Stephens, which did not exist in the present case. The first consideration is that a person should not be the judge of their own life, of the value of their life. This consideration did not apply in the present case, given that the appellant, Brenda, made the choice to put an end to her husband's pain and suffering, rather than this being a scenario where she acted with regards to her own interest in sacrificing her husband's life to save her own life. The second consideration was that allowing the defense of necessity in a case where an innocent life was taken away would cause there to be an absolute divorce of law from morality. In the present case, the appellant is faced with unique circumstances where morally she felt compelled to end her husband's life in order to achieve a greater good, and that is the relief of unbearable pain and suffering when all other means of achieving such relief have failed. My lords, allow me to proceed on to cover the three main elements of the defense of necessity.
I have got a question, counsel.
Yes.
Why is Dudley and Stephens, could you just reiterate, why is Dudley and Stephens not relevant to our facts?
Sure, my lord. In Dudley and Stephens, the courts based their decision on two policy considerations, and the two policy considerations did not apply in our cases because, firstly, the first consideration was that the person should not be the judge in their own course of life, of the value of their life, and hence this did not apply because our appellant made the choice to put an end to her husband's life, was not to sacrifice his life in order to save her own life.
Okay.
Whereas for the second policy consideration was that allowing the defense of necessity in a case where innocent life would be taken away would cause there to be an absolute divorce of law from morality, which did not apply in our case too, because the appellant felt morally compelled to end her husband's life to relieve his pain and suffering.
Okay.
Allow me to proceed, my
Yes.
lords. My lord, it's certainly arguable that the three main elements of defense of necessity, as outlined by Lord Justice Brooke in VA, are present in instances like the present case. First, the act is needed to avoid inevitable and irreparable evil. The apparent evil in the surrounding circumstances in the present case is the patient's severe and unbearable pain and suffering. And if the patient's condition is indeed incurable or terminal, then this evil is indeed irreparable. Second, no more should be done than what is reasonably necessary for the purpose to be achieved, provided that the patient's pain and suffering cannot be sufficiently alleviated by any available treatment, then this can also be established, as there provides the only remaining means of relieving the patient's distress. Finally, the harm inflicted must not be disproportionate to the harm avoided. The question of whether causing death could ever be a proportionate response to alleviate the evil of a person suffering has been addressed by the Canadian Supreme Court in a recent case of mercy killing, the Crown against Latimer, Volume 1 of Supreme Court Report in 2001, page 3. This case involved an appeal by the father who was convicted of murder for his 12-year-old daughter. In this case, the Supreme Court held that defense of necessity was not applicable with regards to the question of proportionality between harm inflicted and harm avoided. It was held that killing a person in order to relieve the suffering produced by a medically manageable physical or mental condition is not a proportionate response to the harm represented by the non-life-threatening suffering produced by that condition. However, my lords, as noted by the Supreme Court, Latimer's daughter's suffering, though severe, was not life-threatening, and her condition was medically manageable. This raises the question whether the Supreme Court's decision that the harm inflicted was not proportionate to the harm avoided would have been the same if the suffering had been life-threatening or terminal, like the one in our present case. My lord, while this decision may be persuasive authority, it is still open to the court to consider that in certain circumstances, like the current one, death can be perceived to be a proportionate or lesser evil than a life lacking quality due to the severe and unbearable pain and suffering caused by a terminal or incurable illness. My lord, allow me to move on to this next
Yes, please.
argument. While in VA, Lord Justice Brooke also emphasized the supreme value we attach to life, and he averred that it is very unlikely for a person to be justified in killing for any purpose except the saving of other life. My lord, it's significant that he continued, or perhaps the saving of great pain or distress. The appellant's submission is that the argument could thus be made that an instance like the one in our current case fits within the second category of saving of great pain or distress, given that the primary purpose behind our appellant's action is to alleviate her husband's pain and suffering. My lords, if the court do accept that the hospital can in theory and in extreme cases be justified from a human rights position under the necessity and proportionality arguments, then the question to my lord is whether it is fair to punish those people who implement and execute the same policy or decision in an individual case. If a private person has to make a decision to end his or her loved one's life, what difference does it in principle make so long as the decision is made along a similar lines as that a hospital would have to make?
So what's your answer?
My lord, my answer is that if the hospital can be justified from killing under the proportionality arguments and necessity arguments, then in an individual case like the one in our present case where the appellant chose to put an end to her husband's life, she made her decision along the similar lines as the hospital would have to make, then it should be justified.
So, counsel, do you mean that it's justifiable for an individual to decide when to terminate the life of another terminal ill patient?
Yes, my lord, because if in theory the hospital can do the same, and if an individual chooses to execute the same policy and decision as one that the hospital would have to make, it should be justified.
Alright, you shall move on.
My lords, in a series of cases in year 1990, the courts have defined areas in which the doctrine of necessity should be applied for the benefit of the patient. And the House of Lords, in the Crown against mental patient sterilization, reported in the second volume of appeal cases in year 1990, the House of Lords applied the common law doctrine of necessity meet by way of declaration the most important and pressing needs of the patient. My lords, even though murder was not involved in the mentioned case of Wee Act, the appellant wishes to bring across the point that the defense of necessity do take into consideration the patient's needs and important welfare, and that the best interest for Mr. Bing is not a continuance of intolerable pain and suffering caused by his terminal brain tumor. Lastly, my lords, Article 3 of European Convention on Human Rights provides that no one should be subjected to torture or inhuman or degrading treatment or punishment. The appellant submits that in denying Brenda, appellant, the opportunity to bring her husband's suffering to an end, the state will be subjecting him to the endless torture that his terminal illness was causing. Allow me to make my concluding submission. The appellant submits that most courts are able to depart from previous decision, and this further suggests that rules alone are not at work in the legal system. A rule does not change, it's there in black and white, but the interpretation of the rules may change because different principles are given different weight in different cases. Therefore, my lords, the appellant would like to submit that second ground of appeal that the defense of necessity should be available to a defendant charged with murder outside the particular circumstances that arose in VA. That, my lords, concludes the arguments I wish to submit on behalf of the appellant. Is there any further issue on which I may be of further existence?
No, thank you,
I'm
counsel.
obliged.